You're watching Your World at 10. Now we continue our conversation regarding the Satyam investigation and the trials and the charges facing Ramalinga Raju, the key perpetrator of that fraud. Now yesterday, if you were watching Your World at 10, you would have heard the Serious Frauds Investigation Office Council tell us that they have filed cases against Satyam's directors. These are for numerous lapses in governance and violations of the Companies Act, and that's going on in a special economic offences court. But the big case against Ramalinga Raju and his associates is one of fraud, and that is being prepared by the CBI. CBI Senior Counsel for the case, K. Surendra, now joins us to talk about the various charges against Mr. Raju. Mr. Surendra, thank you for joining us on Your World at 10. You filed 3 charge sheets against Ramalinga Raju and some of his associates. What is the key allegation that you're making in those charge sheets? Is it criminal conspiracy to fraud?
Yeah, it's criminal conspiracy to defraud the investors as such by fabricating invoices and fabricating documents as such, which resulted in a huge loss of nearly 14,000 crores to the investors.
One of those 3 is with regards to income tax, sort of act violations. Why is the CBI pursuing a tax case?
No. The third charge sheet which was filed, it is for making a false liability as such on the company to the extent of nearly 126 crores. Okay. I mean, by fabricating records. Okay. Now, only the acts which constitute like fabricating documents and all, they constitute offences under the IPC. So these are being they've been already investigated by the CBI and they have filed charge sheet now.
So all the charges that you have filed in those 3 charge sheets are with regards to offences under the IPC.
That's it. We have only confined to the provisions under the IPC.
Because it seems to be that one of the charge sheets was pertaining to some income tax violations.
Yeah, the third charge sheet pertains to income tax violations in the sense these violations were made by fabricating documents. To the extent of fabrication of the documents and filing returns basing on those fabricated documents, the third charge sheet is filed.
All right. Thank you for explaining that to me. Sir, you all were opposed to it, but the magistrate has asked for the combining of all of those 3 charge sheets and for all 3 of them to be tried in one trial. Why were you all opposed to the combining of the 3 charge sheets?
As far as we are concerned, we said that the transaction pertaining to the income tax department fabricating records and filing it to the income tax department, creating a false liability of the company, is totally a different transaction from what the earlier 2 charge sheets have stated. They have fabricated documents into which resulted in loss to the investors.
Okay.
But the court found that these 2 transactions are one and the same. As such, he has ordered for a joint trial now.
So if I understand this correctly, since the underlying transactions on the basis of which these charges have applied are all the same, the magistrate has asked for all of them to be combined in one trial. Have I got it broadly correctly?
Yeah, in a way, since it's correct.
All right. When is Ramalinga Raju going to appear in court, sir, if I may ask you that? Because I'm told since September, he has been claiming that he is unwell and ill and therefore not able to attend court. And now it seems like this trial could be delayed simply because he is unable to attend court.
Yes, now that we're at the stage of framing charges now, and even prior to that, there will be a hearing as per the Criminal Procedure Code. Now, for this, the appearance of Ramalinga Raju is necessary. As such, we have put up a proposal before the court stating that, there's a procedure by which the Supreme Court in one of the judgments stated in a 313 examination that an affidavit could be filed and the charges could be given to the counsel of the accused. Now, on the same analogy, we sought for giving the charges to the copy of charges to the counsel and then getting them answered through the counsel. So it would only expedite the process.
Why have you dropped your demand for a video trial, sir? Because that would be far more effective. Why have you settled or agreed to allow for a written affidavit? We don't even know if Mr. Raju will agree to provide a written affidavit. We don't even know if Mr. Raju will agree to provide a written affidavit, considering that he's been complaining of burning eyes and breathlessness and illness that would require the fumigation of all court areas if he was to appear in court. But why not pursue the demand for a video trial?
No, see, for the purpose for which video trial and the affidavit being filed now is one and the same. If at all he accepts to filing an affidavit saying that he has no objection for the court to hand over the charges to his counsel, then the video linkage can be dispensed with as far as the framing of charges this stage is concerned.
And up to how long does his counsel or does Mr. Raju himself have the opportunity to make this decision?
Now, the court has already asked the counsel to get instructions from his client. Now the case is posted on Thursday for seeking instructions and possibility of filing an affidavit on that date.
So is Mr. Raju really ill, unwell, unable to attend court? Because I do understand that the CBI had asked for a second medical opinion, but that was earlier on. You never pressed for that to happen, and now it seems you've dropped that request as well.
No, I'm not competent to say that. No, whether he is really ill or not, it's for the doctors to decide. Our only endeavor is to see to that
his doctors claim
one
he
way or
is
the other
ill.
he attends the court.
My question to you is not if you know whether he's ill or not, but I want to know why the CBI has dropped the request for a second opinion to verify whether Mr. Raju is so unwell that he is unable to attend court.
No, it's not dropped. It's still pending.
So when will it come up then? Because it didn't come up in the last hearing.
The application for video linkage is pending. The petition, the memo which we have filed for seeking a second opinion is also pending before the court. Nothing is withdrawn.
So now it's up to the magistrate to deal with that request. Am I correct?
Yes.
So you're going to push for a second medical opinion or a second opinion by an independent panel of medical experts to determine whether Mr. Raju is unwell and therefore unable to attend court.
Yes. That is the purpose for which we have filed a memo seeking, asking the court to send for a second opinion.
But I'm sure there is some procedure, sir, here by virtue of which or using which Mr. Raju has been able to stay away from court since September last year. There are all kinds of media reports which say that he is living in some VIP room in the hospital, that he is able to meet with visitors, that he seems hale and hearty. There are sting operations and exposés that claim that he is walking around and he is fine. Has the CBI done any independent investigation to find out? Because ultimately, he is in a hospital out there, in the city. So have you all done any independent investigation to find out whether he is unwell or how this process works from here onwards?
Oh, regarding any exposes and all, I'm not aware as such. But as far as the second opinion is concerned...
Because he's the man at the center of this fraud. He's the man who is the key responsible person for this fraud and against whom most of the charges stand. So have you all done any work on your own to find out whether he is genuinely ill or not?
No, that is the reason we have filed a memo into the court.
But you are an investigation agency, so you don't need just the court to tell you that, right?
Yeah, that's true, but now as a public prosecutor, my endeavor would be only to see to that the trial progresses. Either by video linkage or by filing an affidavit by Mr. Raju himself. So we would be only sidetracking the issue or deviating from the main issue, if at all we go into the factum of whether it's really ill or not. I mean, there are experts to say that.
All right. If your goal is to expedite the trial or ensure that the trial proceeds, can you take us through what the next steps in this trial are likely to be? And I know it's difficult to tell how long a trial will go on for, but if there was any approximate way for you to tell us when this round of the battle is going to come to an end and where this goes into appeal next, because I'm sure whichever party loses will choose to appeal.
No, the time frame, I cannot fix any time frame as there is. And now the stage is at the stage of argument before a charge. Now, if they don't prefer to argue before a charge, the charges will be framed and witnesses will be examined.
Okay.
There are around 680 witnesses and 3,500, roughly 3,500 documents to be marked. So it may take some time.
All right. And thereafter, this proceeds to which level of the appeal system?
In case of a conviction, it goes to the Sessions Court.
It goes to the Sessions Court, thereafter the High Court, and then the Supreme Court. So there are 3 levels of appeal available to whoever loses.
That's right. To the High Court, they go by way of revision. and to the Supreme Court by way of an SLP. I mean, that is too far now.
No, I understand. I'm just for academic purposes trying to understand how the process works. One final question, Mr. Surender. You said that the major thrust of all the charges was criminal conspiracy and the intent to defraud. What is the maximum punishment that can be, sort of applied for a charge of that nature?
See, for cheating, for 420 of IPC, it's 7 years.
Okay.
And as far as 409, Section 409 is concerned, it's life imprisonment is there.
So it could go all the way up to life imprisonment.
Yeah.
All right, Mr. Surender, all the best.
But it depends on the powers of the the trial judge who is trying the case. I mean, it depends on his powers to give the sentence.
What do you mean by that? Depends on his powers to give the sentence?
Normally, Criminal Procedure Code restricts a magistrate to give imprisonment up to 3 years.
So if he is convicted in this court, he would get a sentence of only up to 3 years?
No, depending on the conviction given by the magistrate, whether it's concurrent or how the sentence is to be carried on.
All right, Mr. Surender, thank you very much for providing us with all that information and updating us on the progress of this case. That was K. Surender, and he is the counsel for the CBI in the case against Ramalinga Raju, the main charge being of criminal conspiracy. With that, we need to take a quick break on Your World at 10, and we're going to come